Good morning. We are delighted to join you this morning to continue with our Title IX series, our top 10 Title IX series that we've been doing since January. We started out earlier in the year with a webinar covering the top 10 questions that school administrators have been asking about Title IX. And last month we took a deeper dive into investigations. And so today we will be taking a closer look at decision making and written determinations. And we'll also be talking about the Supreme Court decision that was just announced earlier this week. I'm Amy Dickerson, and I'm happy to be here with my partners Brandon Wright, Jennifer Smith, and Ellen Luking. Our Title IX focused webinar today, again, we'll be addressing the topic regarding reminders for school administrators when they get to the decision making and written determination phase for the Title IX grievance process. Similar to last month, we will be reviewing these at a pretty high level as we're only set to be together today for about 30 minutes. So we'll try to focus on the key things we want administrators to keep in mind with these topics. And then certainly, as is always the case, you can follow up with us afterward to take a deeper dive and to particular questions that you may have for your institutions. Although our Q&A function will be open for today's webinar, so please do submit any questions that you do have top of mind, and we'll do our best to address them either during our time together today or following up from the webinar. It's been great to have this space here already scheduled because as a result, we're also able then to bring to you some initial thoughts regarding the Supreme Court case that was also just recently announced on Monday related to the disclosure of students' gender transitioning status to parents under a particular California law. So we're actually going to start out today with addressing that as well. For those of you that sign up for our alerts, we did issue an alert yesterday that provided an overview of that decision, and we will go ahead and share a brief overview of that and some initial thoughts as well. So with that in mind, I'm going to turn it over to Ellen to get us started on providing an overview of that case, and then we'll move on from there. Ellen?
Yeah. So this Mirabelli case is pretty interesting. This case started in the Southern District of California, and it was over a California school policy, which was required or reportedly required by state law and by the California Department of Education's interpretation of that law. And like Amy said, it required schools to use the preferred pronouns and names of a student, even against parents' wishes, and not to disclose the gender identity status of a student to their parent without the student's consent. What happened from here was two employees sued requesting a religious exemption from this policy. After that, because the school said, we only have this policy because the state requires it, the California Attorney General was added as a party, the California Department of Ed was added, and a whole class of the parents of California school children were added to the lawsuit as plaintiffs. The district court ended up entering a permanent injunction to, quote, prevent the school from misleading parents about their children's gender presentation at school and their social transitioning efforts. And it also required the schools to follow parents' directives regarding children's names and pronouns. The Ninth Circuit stayed that injunction. They said, hold on, we're not going to enforce that injunction. And they cited to some procedural matters, which I'm not really going to discuss a whole lot with you, but they focused primarily on the decision on the merits, and they did not believe that was correct. The Supreme Court took it up, and they focused really only on the parents' argument in this case. So we're not going to do a whole lot of talking about the employee side of this case, how this case actually originated, because the Supreme Court looked really at the parents' arguments. So the Supreme Court found that the parents were likely to succeed on the merits of their free exercise and their due process claims. Focusing on that free exercise claim, they noted that the California policy was subject to strict scrutiny because it substantially interfered with the right of parents to guide the religious development of their children. The Supreme Court went on to find the state's argument of a compelling interest in student safety and privacy failed because the policies that were required weren't so narrowly tailored. They didn't in effect, they cut out the primary protector of children's best interest, their parents, and it could have been the safety interest could have been served if they had narrowly tailored it to not disclosing identity to parents who would engage in abuse. And the Supreme Court also found in favor of the parents on that due process ground, like I mentioned. It said that the parents, not the state, have the primary authority with respect to the upbringing and the education of children, and resultantly, there was not a right to be shut out of participation in decisions regarding their children's mental health, such that policies likely violated parents' rights to direct the upbringing and education of their children.
Whew, that's a lot. So, Ellen, a couple things. This was procedurally, this was an emergency injunction and it's about a California law. So I'm about to say some things that probably overread it, but just in terms of issue spotting, the court's analysis was fascinating and does have a lot of implications, but we do want to caveat it with this was procedurally and actually a very narrow ruling because it's just on this emergency appeal. Having given that caveat, though, let's talk about their analysis because it really just opens tons of cans of worms.
Yeah, I think it's a big warning. I think it gives us lots of information about where the Supreme Court intends to go if it sees similar policies in other places.
Right. Well, and here in Illinois, I think it's been a bit of maybe murky or people's understanding of when to involve parents in gender transitions has been something that there's not necessarily agreement and common practice among Illinois school districts. And this really suggests there's some significant risk in not including parents in those discussions, supports. So I think there's kind of a spectrum of thoughts. One, I think some of our clients really have firmly established formal processes for offering support for gender transitions, and that include often a parent, done in different ways, but some sort of parent cooperation, information. And I think those practices are really going to serve those districts well. And for schools that are less formal, they might want to take a look at some things their neighbors are doing and get some formality. I don't know. What do you guys think about that as a takeaway?
I agree. I think one of the things that stands out to me about that is the framing of the issue. And as Ellen mentioned, part of the way the court, or at least the plaintiffs framed it, was that the school district was misleading parents, or not being honest or transparent with parents. And I think that that's obviously something the Supreme Court has tipped their hand a little bit to show that that is a big concern for them. And so I do think, Jen, that that is probably wise to be thinking about having a very specific protocol that we can make those decisions in a way where process guides good decision making. Because I think when we get too informal, sometimes that informality can lead to, results that can be challenged.
Yep, I agree. I was even looking this morning kind of at the non-regulatory guidance and sample procedures that we know ISB has put out. And was looking at, even as part of a framework that a school district might use, we often see there being something, for example, in there that states if a student has expressed concern for safety or health about disclosing or sharing information with parents, then then it's built into the process in place to do an assessment of risk with the students there to assess what additional supports may be put in place or to assess that. And I think that the language from the case could still support having that mechanism as well that I think a lot of our districts use.
Yeah, the second piece that I'm finding a little perplexing or really, trying to roll around what implications there are is the court talked about a due process right, a right to be involved in their child's mental health. And while gender dysphoria is a mental health concern, not every gender transition would automatically present a mental health concern. So I'm a little bit trying to wrap my head around what do we do? And even in the facts of this case, the gender transition might have predated any knowledge that there was a medical diagnosis. So I'm not sure that we exactly treat, we don't necessarily lump this into our 504 or IDEA process. Um, the court talks about Mahmood, and that was the curriculum case where we had a big, avenue of compliance, which was the opt out. I mean, so one thought I had is, do we take a Mahmood approach and just say in our handbook, like if your district has a practice of supporting students on these issues, you list in your handbook what your supports are and say, tell us if you want to opt out, and then we're covered. I mean, maybe it kind of suggests, I mean, if you have more individualized concerns or knowledge about a specific student, maybe that's not going to be enough, but I'm not sure, that there's probably some approach there.
Yeah, I think two things stand out to me about that. Not to make our whole about this case, but it's an important, timely decision from the Supreme Court this week. I think that the Supreme Court's language in this decision, brief as it was about Mahmood, stood out to me because what we've seen since the Mahmood decision, which was a curriculum case and opting out of the curriculum last summer, is that some other courts around the country and lower courts have been trying to limit it to instruction and curriculum. And the Supreme Court seems to suggest in this Mirabelli decision this week that Mahmood is not limited to instruction and curriculum, which definitely broadens that opt-out piece. And I think that's a bigger policy picture for me. The other thing, Jen, when we come to that mental health piece, is I also think about like we have other state laws that might impact that, like the Right of Minors to Counseling Act and the ability to see a counselor so many times before you're required to notify the parent, and that there are some language in that about when you might be able to not notify the parent based upon legitimate concerns. So maybe that might be a place that we look to for kind of an analogous analysis. Um, and that Right of Minors to Counseling Act might be a place that we look at for those procedures.
Yeah. So probably more questions than answers on this case, I think, for today. But certainly, I've already had questions, about certain practices. What's the implication? Should we get parent consent or parent opt-outs of, maybe you have an upcoming event or training that those should be on people's radar. I think this is a real presents real issues when we're talking about a new expanded constitutional right of parents. I mean, that is a huge risk and something to address, proactively. But I can shift us into, I'm the first one to talk about just back to our regular scheduled content here. Um, I was going to talk about so we're talking about decision making. First step, who is your decision maker? And you've already heard on our other webinars, decision maker has to be trained. What I wanted to emphasize about this is sometimes I'm asked whether boards of education should be decision makers, could be decision makers, because that's often an appeal place for these cases, for cases to go under board policy. Um, could happen, but strongly recommend against having your board be your Title IX decision maker. And one of the main reasons is because they have to be trained. And do you really want to be doing Title IX training for your Board of Education? That is not a good idea. So basically, this is going to end before you get to the board. Some sort of administrator, often the decision makers, a district administrator or principal, maybe at a different building. Both of those would be common avenues. So, with that, Brandon, well, what do you have to share today?
And I think the next point I want to make about that is that we have to actually be willing and able to make decisions. We just have to quit being scaredy cats and make a decision. And I think that in these Title IX cases and in sexual harassment cases generally, over time, over the decades, there is a tendency to want to fall into a he said, she said, it's a tie, I don't know who to believe, right? Well, there's even, 6 Degrees of Kevin Bacon, right? Wasn't there a Kevin Bacon movie called He Said, She Said, right? About um, way back in the day, right? And I do think that sometimes we get to that, well, I don't have a direct witness who saw it happen. I don't have a video that I can rely on. And so I have the complainant and the respondent who have each given me their side of the story, who have shared their stories with me. And so it's a tie. And I think that we have to be careful about that and be willing to make a decision. And, a good investigation, go back to our last webinar where we talked about those good investigation pieces, is going to give us the information, the facts, so that the decision maker, who is a separate person from the investigator under our current rules, has what they need to be able to actually make a decision based upon the preponderance of the evidence standard. And you can make a decision simply because you believe one party and not the other when that's based upon all of the other factual determinations and credibility determinations and things that Ellen's going to talk about next, right? And so, moving into that piece, we just have to not be afraid to actually make a decision and then use the factual findings and the credibility determinations that we have based upon the good investigation so that is way more defensible, right? I would rather defend that you made a good decision and base it on the facts than that you went out and didn't make a decision at all, right? I think it's much easier to defend at that point. But of course, to do that, we're gonna have to make good findings of fact and credibility determinations. And I'm gonna let Ellen talk about that now. Unless,
Yeah, and yeah,
Amy, you had something you want to weigh in on it?
I just want to jump in and just, to I think what can help with doing all the things that you just guided us on, Brandon, is really in your determination, really relying on those good, and objective, articulation of facts that do weigh, one side, that sway you one way or the other, and really rely on, language that refers explicitly to the preponderance of the evidence standard and whether it's more likely than not. And relying on that, relying on the evidence that you have in front of you, relying on those policy definitions, I think as you're articulating the determination and really using language that refers to those explicitly, I think can really help in, taking you, the decision maker, out of it and just doing, making it clear that the task at hand is really to apply what evidence has been gathered to what the required elements of the particular policy definition are, to make a determination under your standard as to whether it meets that. And I think the more you can really rely on that as you're writing it, the potentially easier it is to be able to just ground your determination in these objective considerations.
I'm going to jump
So
in.
Ellen,
Yeah.
yeah, help us think through those factual and credibility determinations.
Yeah, so factual determinations are a required part of a written determination under the Title IX regulations. You must make factual determinations factual findings to support the ultimate determination that is made. And I think a lot of times we end up in these pattern cases where there's, 3, 4, 5 allegations that are alleged to arise to a pattern that is now unwelcome and severe and pervasive and objectively offensive, such that it denies someone equal access. But to get to whether it is unwelcome and severe and pervasive and objectively offensive, you have to make factual findings to get there. So you have to take each of those individual allegations and parse it out. Does the evidence that you have in the investigation report, in the directly related evidence, does it support a finding that did happen? Or does the preponderance of the evidence support a finding that it did not happen, or the preponderance of the evidence isn't there? On each one of those, you need to parse out. We don't want to lump everything together and say, as to this whole pattern, I can find. I want to see it each individually because that helps us whenever we move into what Amy's going to talk to you in a little bit about making policy findings. And then something else Brandon mentioned while he was discussing what I'm going to just discuss was making those credibility determinations. A lot of times in Title IX cases, we're in a he said, she said situation where there's not alleged to be a video, where there's not alleged to be any adult witnesses or any witnesses, period. And so we can't rely on the fact that there are no witnesses, that there are no videos, because there was no reason for there to be a video, for there to be a witness. We have to turn then to our credibility determinations. Whose story is more believable at the end of the day? And that can be based on any number of things. That can be based on corroboration of other instances that where a complainant had testified consistently with what everyone else said all throughout the case, but on this one factual allegation, there were no other witnesses. Well, in this case, respondent denied, like respondent had denied on all four of the other allegations, and all four of the other allegations, there was a preponderance of the evidence. I think you have enough there to believe that complainant across the board is more credible than the respondent has been. We can have other things, like there has been consistent testimony of this complainant. They immediately went and reported to their school counselor. After that, they told a friend. After that, they told their parent. It was the same story every single time. And then they told that same story to the investigator when they made their formal complaint. That kind of consistency might help us get to a credibility determination that they're more credible than the respondent is. On another occasion where we have a complainant who tells a different story to each person they talk to along the way, I'm going to have trouble finding that complainant to be credible. So I'm going to turn it over to Amy now to talk about how we use all of those determinations to then look at our policy.
Thanks, Ellen. Yeah, so once you make a determination on the facts of what is more likely than not to have occurred, weighing the credibility considerations that Ellen just went through, you then have to make a determination on whether there was a policy violation. Important at this stage, I think, is to really pull out the specific policy definitions that apply to the particular case that you are making a determination on. So if the allegation involves a claim of hostile environment, sexual harassment, then you'll need to determine whether the conduct that was found to have occurred based on your factual and credibility analysis that was just conducted, whether that the facts constituted severe and pervasive and objectively offensive conduct, and whether there was a denial of the complainant's access to the environment. So I find it really helpful to do this analysis and to articulate this analysis is to really have the actual policy definitions in the determination itself, even having a policy section in the written determination that identifies exactly what those definitions are. And then that can really help to explain the conclusion that you're arriving at when you're able to, refer right to those. So to have that there, and then to be able to, when it's a close call, really show your work as to how you got that, as we talk about in the trainings, can be really important. So with that, then I'll, turn to talking about, once you're done with that determination, thinking about, as part of our written determination, we have to give that notice that parties do have the right to appeal. So just keep in mind that unlike when we're doing appeals for like our uniform grievance process, where most of those policies do allow for a broad appeal for just generally if you wish to appeal, under the Title IX grievance process, there can only be an appeal for one of three reasons: that there's an assertion that there was a procedural irregularity that affected the outcome of the case, that there's new evidence or information that wasn't previously available at the time of the outcome that could have altered the decision, or that there was a bias or conflict of interest of the Title IX coordinator, investigator, decision maker that altered the outcome of the case. So when you're considering this question on appeal, those are the narrow focuses. And so in the making the determination, it really does have to be narrowly focused on both aspects of whatever the particular basis was. So if you have a appeal due to a procedural error, you're making a determination first on, was there actually a procedural error? Was it more likely than not that there was a procedural error? And then even if so, would it have affected the outcome of the case? And I'll turn it over to Brandon now to talk through that particular analysis further.
And I want to emphasize as we think about sort of that appellate decision analysis, I want to emphasize a point that Jen made at the front end of this about who the appellate decision maker ought to be. Because the default policy that most Illinois districts using say that it will be the board or designee, and I think that we need to focus on the designee for exactly the reasons that she articulated. I think it's really hard for a board to do the job of an appellate decision maker because of the requirements to, be able to review, the evidence, to be able to issue a written determination. That's hard for a group to do. And I feel that the way the regs are written in those things, that analysis is better served by an individual and a properly trained individual than a group of people to be able to do that. I don't think Title IX appellate decision should be a group project. But when we get to that appellate decision analysis, there's sort of two things. And the first is really what Amy focused on is remember that there is a very narrow set of bases for appeal. And the first question the appellate decision maker has to answer is, has that basis for appeal been met? So what the appellate decision maker is looking for in the statements of appeal that and responses that have been submitted by the parties, is really looking for, is there evidence to support that there was a procedural irregularity or bias or new evidence that was not available? And even if true, would it have affected the outcome? Right? Just because there was a procedural irregularity, or just because there may have even been evidence of bias, that doesn't automatically mean that the decision must be overturned. It has to result in a finding that it did affect the outcome of the decision. So the first step, right? We got to have a finding there from that appellate decision maker on whether that basis has been met or not. And then second, what do you do about it? Um, do you, if adequately alleged, do you overturn the decision? Uh, do you affirm the decision if there is nothing there still, or do you send it back for more investigation? And I think that that's where, the appellate decision maker's job is not to become a new investigator necessarily. And so there may be times that we've got to think about maybe that requires additional investigation, and we need to send the process back a little bit. Or maybe the facts are such and what's been alleged that there's no material dispute of fact, and then a decision could be made at that stage. But really keep in mind the narrow band of that appellate decision maker, and it's not just a free for all, but we've got to focus on those legal standards and the regs for that.
Just a purely practical note. Sometimes I think about this as an opportunity. This is our last internal decision point. And after this, it's going to go, if the dispute continues, it will go to a third part, like either a court, an agency. Are we good with that? Do we have any concerns that we want to shore up, with a remand? And not every investigation is going to be perfect, but are we ready to go to court on what we've done up to that point, or are we nervous? Because if we're nervous, I might find a way to use one of these.
I agree, and just to be transparent, the mechanism I might find easiest to do that is to say that there was a procedural irregularity. So I'm going to send it back to the investigation stage so that then we can cure those irregularities so that we've got a defensible product at the end of this process.
Right. This is our own internal do-over opportunity, but before we let it go into the world, and then we're stuck with what we did. But speaking of getting ready for it to go into the world, so our last step is record keeping. Keep all your records, obviously. We need evidence of all these things having happened, and we have to keep it for 7 years, which is a different amount of time than other records requirements. So just make sure your systems enable you to comply with that.
Jen, I've gotten the question quite a bit recently about, do we put those written determinations in personnel files and student record files?
So I think they are student records because we don't, that's a little bit of a different question because anything that identifies a
Right.
student is going to be a student record. I mean, it doesn't go in like the permanent, file or something, but it identifies the student and we'd have to produce it in a student record request. Amy, what do you think about the personnel file?
Yeah, I think you have to, I think we have to look at that sort of in the context of, where of where it is in the broader sort of outcome of what's occurring. I think that one thing that I think we get questions about when it comes especially to Title IX matters too is we think about like the file versus confidentiality of records, especially when we have multiple individuals that may not just be a personnel or an employee in a file. And so I think that with the quick answer thing, I think I would think about is that you want to be thinking about sort of, at minimum, both is it a record, but then also just how are we managing those in terms of who has access to that information so that, we're keeping things when they need to be confidential. If we do need to disclose records, that we're making appropriate redactions. But it can be really critical. You want to make sure you have systems in place that are speaking to each other. Because I think that the biggest thing I see is that, we might try to have a system in place to maintain certain records confidentially, to be mindful of that. But then when we go to look at, to look at an employee file for the purposes of determining whether something has previously, been an issue before or anything like that, if we don't know where to look, if not everything is in that one location, then that's when there can be concern. So I think, going back to Jen's point about making sure you have systems in place that are not only maintaining these, but that are also communicating with each other, so where anything relevant may be for a particular employee, where that's living.
Yeah, there's no bigger killer. Amy and I have had several matters where something, there's real serious allegations, and then someone remembers, well, there was something that happened maybe 10 or 15 years ago. Nothing's in the personnel file. No one knows where it may or may not be. Can't find any emails. Those are really hard, legally risky situations. So, whether it's keeping specific Title IX records, um, and you know where to find those, or maybe outcome letters might be in the file, but not the whole report, for example. Like you said, it kind of depends on the outcome of the what the allegation was and the outcome.
And that might be necessary for us to be able to comply with face law in the future if there was a finding and if that conduct met that definition of sexual misconduct under faith law.
Yeah. All right. Well, with that, we'll wrap up today's webinar. Thank you for joining us for this series, and reach out if you have ideas for other series you'd like us to do. We are in the brainstorming process right now, so you'd hit us at a perfect time. So looking forward to it, but thank you for today.